the first to know Nsem-Pii TV.
It was for former Chief Justice Torkonoo ewo court sisi amene ekasa na in fact ene maame no afile a judicial review application challenge say John Dramani Mahama kwan a wafa so a wode no ayi no afi ho as Justice of Supreme Court no ade bia ni tumi enuru ho na yedi anase say enchei ana John Dramani Mahama declare say wayi Chief Justice Torkonoo afi the office of Chief Justice Dibreno na John Dramani Mahama ne nkasa yemu no osai to aso kan say wayi maame no afi Supreme Court justices no emu eno ne maame no afile judicial review application say John Dramani Mahama court emhwe ma no because maame no say John Dramani Mahama abuse the power no sanso so abuse article 146 no na enne maame no kopie mu court no in fact enne wa gani root pa ama enne lawyers akese wo man Ghana mu ha ena chese back maame no the likes of Kofi Bentel no Vice President Imani Africa ene empo former Deputy Attorney General Alfred Tuayeboa eno nyara ene Martin Kpebu no back maame say maame no deserve to be part of the Supreme Court justices na ene de enye fedi agrokra omo nyina catch John Dramani Mahama say untimi go beyond the 1992 constitution amamra na nyina yigina so a wo so gina 146 so eyi maame no free ho no untimi go beyond that enyi maame no free ho as Justice of the Supreme Court and then penny for ya kasapa actually John Dramani Mahama yentie ensema ekopie free court ene.
Well, you're right, but that's the point. She qualified to become a Justice of the Supreme Court, which means she passed all of that. Then when you become a Justice of the Supreme Court, you are picked from the team to become the Chief Justice. Okay? Now, when you are removed as Chief Justice, it does not mean that the qualification that brought you to being a Justice of the Supreme Court is all of a sudden removed. Because what moves you from the Justice of the Supreme Court to the Chief Justice is different.
Is stated misbehavior not a proven case of breaching high moral standards or character as stipulated in 128 of the Constitution?
That's not the issue. The point I'm making is that...
Why is that not the issue, though?
Well, that's not the issue because he passed all those things to become a Justice of the Supreme Court. Okay? And now she's moved as a famous enterprise to become the Chief Justice. She's all of that plus. If she is dropped from the position, like I said earlier, if you have made the head because they think you have some leadership, special leadership qualities, and therefore you're not the head of the team at what is your program called? Morning show. Okay. And for some reason, you are removed because you didn't do that job well. I think there's an argument that you should be returned to your original position. There is this thing in HR called being promoted to your point of ineptitude. Some people are good at a point. When you elevate them, they may not be that good at that point. So I'm simply saying, the processes have not been exhausted. There is an argument to be made, whether it will go in her favor or not in her favor. It is useful for the rest of us that this matter be put to rest once and for all. What I say, or what my colleague Martin will say, is not the law. These are our views. It is properly before the Supreme Court. Let them take a look at it and let them make a decision on this matter. And then we'll the advice going forward. But I do think that she does have a case. Because in future, if you become a Justice of the Supreme Court, you may be very suited to become the Chief Justice. But if you look at what is going on now, and you are giving the Chief Justice, which can help the whole country, you will refuse. Simply because anything, including making a mistake on accounting, can lead to your removal of the Chief Justice, and then you also get removed as a Justice of the Supreme Court. Very good people will refuse to take that position simply because it puts them in bigger jeopardy than the benefits that they gain from being in that position. So I'm simply saying there is room to look at this and let the justices of the Supreme Court deal with it. Right. In a constitutional republic, nothing is final until there's a final judicial pronouncement on it or the statute of limitations passed. So to the extent that she has not exhausted all these, I think it is proper to bring this matter. People are giving her advice and saying it is not good, you are disgracing yourself, you stop fighting. All of those things I don't think are the law.
Okay.
She is good enough to advise herself, and she has advised herself. I am happy that she's doing it, and I think I'm waiting for the outcome.
All right. Now, why go through a process that doesn't include 1464, and then at the end of it, release an outcome that includes the outcome of 1464? Why not simply go through 1464 as well before you then have the outcome of 1464? By the way, I'm using numbers, but I'm simply saying, Chief Justice removal is under 1462, I believe. Five. Forgive me. Right. So you've done 1465, and you've removed her as Chief Justice. You have not done 1464, but you have removed her as Supreme Court judge. Why? 1464 exists. So go through that to remove her as Supreme Court judge.
Okay. No, I would not, because the 6, the 1464 and 5 are many. Let me just be sure that when we said 5, that was it. Yeah. You see, let's do this, Kojo. The simple matter is this: the Supreme Court has held. Okay, so 1466 is a Chief Justice.
1466.
Yes,
Thank you.
Exactly. So 5 is the recommendation for the removal of a Superior Court judge.
Right.
Look, it's simple. The Supreme Court has held, in 2 cases, and you even 3, because you mentioned the Aban case. In the J2, and then in Justice Torkonoo's own case, they say it's a consolidated process. It's 2. It's a consolidated process of removal as a Supreme Court judge and removal as a Chief Justice. Let me read a short dictum by Justice Tanko in the recent one. So if that is the case, I'm wondering why they didn't take issue with the ruling of the Supreme Court when it was given. Because Justice Tanko was very clear, Amadou Tanko, was very clear that, look, this process involves the removal of the Chief Justice as Chief Justice and also as a Supreme Court judge. That's why, let me just go straight to it. It says this: I have arrived at the conclusion that this application must fail without relish, mindful of the fact that the applicant, the Honorable Lady Chief Justice of the Republic, is going through a process that may define her career on the bench as Chief Justice and as a judge. Chief Justice and as a judge is 2. Then we go to the one you read earlier, Pega. Then there is a J-Chum. I've been scrolling since I came. I wanted to get the page in a J-Chum. A J-Chum, a J-Chum case, that's Dateba. He gave the the lead opinion of the Supreme Court, and Justice Ofekufu and the rest concurred. Of course, Justice Ofekufu later on wrote a small opinion where she stated her misgivings about the nebulous nature of stated misbehavior, asking that there should be more flesh, and also in terms of the procedure, more flesh. But generally, she concurred with Justice Dateba. So it's been very, known to us in the legal community that it's a dual process, 2 in 1.
That first reference you made, and the quote that you read, I note that, and I'm just trying to be fair here, I note that he says that the procedures that they are going through may affect Justice Torkonoo's career as a Chief Justice and as a judge. I don't know that we are being fair if we say that means may remove her as a Chief Justice and as a judge.
Oh, that's the meaning.
Because you can affect her career as a Chief Justice in one way and affect her career as a judge in another way.
I get it. The devil's advocate.
Yeah, it's only fair to point that out, right?
Yeah, why not? But for us as practitioners, it's not a question that really excites our mind that much. You see how Blessed took it, and you yourself, you earlier referred to it. It will be incongruent to say that those facts that have been proven against her relate to her office only as Chief Justice. Those same facts, let's go over this. We lost over 300,000 in terms of per diem and tickets, right? And somebody is saying that these are trivial. This cannot meet the threshold of failing to keep the public purse, and so the Chief Justice cannot be removed in the dual capacity. We are joking. Look, millions of our citizens don't earn even 100,000 Ghana cedis a year, annual salary. Millions. When this matter came up and we're making the $10,000, even if we took it today, even since this government came at a point we're at 10.5, right?
Yeah.
Even if you call it the lowest, 105,000. I was shocked that some teachers who had been in the classroom for over 15 years said, look, they don't earn up to 100,000 a year. You ask policemen, etc. So millions of our citizens. So those who are saying that these things are trivial, and I see that they've lost touch. They really don't understand the incomes of Ghanaians. These are graduates. People have gone to school, finished university 15 years on, can't earn even 100,000 Ghana cedis a month. And this is money that has been given to a daughter on one trip, not more than 2 weeks, $10,000 per diem. Then the spouse also gets 6,000 on another trip, right? No, that's a misapplication of the funds. The public purse wasn't well kept, and the other grounds. So look, they relate to the dual roles. And let me make this clear. Look, the case has been sent to the High Court, right? But if you look at what Justice Torkonoo is looking for, the High Court can't grant that, because that would be an interpretation of the Constitution. So it means they have to go to the Supreme Court. You heard even Kofi refer to the Supreme Court twice or so, meaning that in Kofi's mind, he thought that the case is in the Supreme Court.
Why do you say it would be an interpretation of the Constitution?
Because of these various statements we've read out. Quotes from the various cases. So it's seen that our judiciary has shown that for them, when the person is being removed as Chief Justice, the person is also being removed as a Justice of the Supreme Court. So to go and ask a junior judge, a High Court judge is senior, okay? High Court, Court of Appeal, Supreme Court, they belong to one class. But within that class, the Supreme Court is senior to the High Court. So a High Court judge, in view of such statements, would not. Either the judge will throw out the case, or at best say that, okay, I'm setting down an interpretative issue to go back to the Supreme Court. Yes.
Power. My question, when you saw the application for the judicial review, particularly on her removal of the removal from the bench.
Yes, I've seen the application. I've gone through the application, and I see merit in the application. Now, if you look at the jurisdiction of the committee, as you really indicated when you were having a conversation with Honorable Inusa, you realize that it is a lower adjudicating body. Even commissions of inquiry, their decisions can equally also be questioned. So this particular committee set up by the President pursuant to Article 146. It's not a committee that you can say has limitless powers and can do anything that it wants to do. That committee is subject to other provisions in the Constitution, even though no explicitly stated. So far as the committee, any aggrieved person can go to the High Court, invoke the supervisory jurisdiction of the High Court to challenge certain aspects of their report. In this particular case, the case of the former CJ is that the petitions against her were for her removal as the Chief Justice of the Republic. Especially if you read the petition that was heard and got her removed. And so, if the committee that sat on the matter were to determine any other issues, the only issues arising out of that petition definitely were issues relating to her capacity as the Chief Justice and not as the Judge of Superior Court of Judicature.
Will it not be quite odd in law? Will it not be quite odd to know that the position that allows her to be the Chief Justice will not be in question?
That is rather, this proposition rather make it odd. You see, you must first and foremost be a superior court judge before you can be appointed as the Chief Justice. And so it is permissible and possible legally to lose your position as the Chief Justice, but still keep your position as a superior court judge. In any event, a Chief Justice may choose to resign as a Chief Justice, but that will not mean that she has resigned or he has resigned as a superior court judge. And so every Chief Justice wears two hats, as I explained yesterday. However, on the flip side, if you want to remove a Chief Justice, you have various options. You may want to remove that Chief Justice as a judge of the Superior Court. If you succeed in that one, automatically, the position of the Chief Justice is also lost.
Okay.
But if you start from up, and that one succeeds, it does not mean that the second one, the head position, will also have to go. Let me give you this example. If you go to Parliament now, you have the first and second deputy speakers being members of Parliament, and are also first and second deputy speakers. Does it mean that if Parliament by resolution decides to remove the first deputy speaker, and they succeed in doing so, it means that he's also going to lose his position as a member of Parliament? No. So if you want a CJ to remove the judge of the Superior Court, you must expressly, in your petition, indicate that the CJ, apart from her administrative duties as a CJ, is also not fit to be on the bench by virtue of reasons A, B, C, and D. If you fail to do so, as well as to tell you, the costs are not there to give unsolicited release. If you have not sought for removal of a person as a superior court judge, the committee sitting on it cannot make orders on release that you are seeking. I mean, some lawyers may be thinking that there's a decision of Hannah, IEC, and the rest. But in terms of this particular committee, the question I pose is, after the hearing of the matter, did they recommend to the president that the Chief Justice be removed as the Chief Justice as well as a Justice of the Superior Court?
Well,
if that was not the situation where the president, with all due respect, by issuing that warrant, removing the Chief Justice as a Chief Justice as well as a Justice of the Superior Court of Judicature.
For purpose of learning, just some purpose of education this morning, assuming that report by the committee included that she be removed because they found out that maybe the processes of removing a Chief Justice will be nearly the same processes that will be used to remove a Justice of the Supreme Court, and the Constitution says the President shall be bound by it, will they have erred then? Will the President have erred then?
In that case, the President may file a defense and say, yes, I only followed the recommendations. And that will be a defense for the President. But the committee may then be sued in the same manner so that that aspect of the recommendation will be quashed.
Okay. Mr. Yeboah, again, for purpose of learning this morning, if you look at that committee, because it constitutes or it had justices of the Supreme Court, in fact, one as chair, if their report or their findings or their decision, because of our conversation, is then subjected to the review of the High Court, what does it look like legally?
That is the legal position, my sister. If you are even the Chief Justice and you sit in a committee and you come out with a report, that report can be questioned by way of judicial review at the High Court. It matters not the persons who sat on that committee, and there are various incidents to that effect. So when it comes to judicial review, you're not looking at whether you were the Chief Justice who sat on the matter or the Justice of the Court or of the Supreme Court.
Right.
And so the High Court is the appropriate forum for the examination of the particular matter. But maybe let me respond quickly to my learned friend, Honorable Staley. Now, a point has been made by him that you can be removed as the Chief Justice, and the moment you are removed, automatically you forfeit your membership on the bench. I beg to differ. If you look at the Constitution, Article 146, It has done two things. First one is the removal of superior court judges. Second one is with regard to the removal of the Chief Justice. It's not for fun that the Constitution decided to segregate that kind of superior court judges and then the Chief Justice. So the Constitution contemplates a situation where the Chief Justice may be removed as the Chief Justice, qua Chief Justice, which may relate to the Chief Justice performance and administrative officer or head of the judiciary. In that regard, they perform administrative functions. So if you want to remove a Chief Justice, qua Chief Justice, you focus on her administrative function, the Chief Justice. If you want to remove a superior court judge who in any way does not perform administrative functions, you look at that person's judicial function. And so far as the petitions that we had, especially the one that was heard, the other two, the one that was heard, does not relate to the Chief Justice's performance as a judge, but as the Chief Justice. If that one has succeeded, CJ could be removed, but her position as CJ is still intact because her judicial function have not been questioned by this particular petition. In any event, you look at the three main grounds that the committee came up with. None of them relates to the Chief Justice in her capacity as a superior court judge.
Okay.
And this legally tenable.
Okay.